just remove the first part of roasting. Anything you need, let me know. Moving down again.
Do you want to change to gin?
Oh, it's okay.
Or do you want to change take one?
No, it's okay, so I just want you. Just like hover your cursor over the bar. See the ink. No, there's still more. Damn, okay. That's pretty funny.
This one we just wake you up.
Yeah, we'll probably this one. You use our phone discreetly. I just put it on the table, then you blend it. Privacy shit. This one. Those two. Change the layout. Yeah.
Gabby. The speaker.
Should be multi speakers.
Am I audible? All right. Good morning. Greetings, everybody. Mr. Arbitrators and Madam Arbitrators. I am Aminish, bailiff for this hearing room, and alongside me would be Erin, the timekeeper for the session. May I know who will be the presiding arbitrator for this round?
I think we should let our overseas guest be the presiding arbitrator. Agreed, Erdina?
I was suggesting to go the other way around. since I'm joining from overseas, I thought maybe I would invite maybe one of the judges, one of the arbitrators from Malaysia to take the lead, and I'd be happy to follow.
Actually, I think it doesn't matter. I mean, whilst they expect the presiding person to actually be the most active one, but I think all three of us will be equally active. So I think it's just like a welcoming thing. You would have you'll be flanked by the Malaysians, and given that it is an international tribunal, I think it would be very nice for Asil if you're agreeable to be the chair.
It's very kind of you to offer, and I would be obliged to accept. But however, I would be very grateful, Janet, if you could perhaps take the lead, and I'll be happy to contribute thereon.
Okay, we'll all be equally active, I'm sure.
Dear members of the tribunal, I have sent the reference for the time allocation and the full name of both the respondents team and the appellants team for your reference. The arbitration is now in session. Mr. Arbitrator Hasil Hassan, Madam Arbitrator Irina Azira, and Madam Arbitrator Janet Chai Pei-Ying are presiding. The case before the panel is the arbitration between the appellant, Ms. Towns and Mr. Landed, and the respondent, the Global Disciplinary Commission, GDC. The appellant and the respondent have both 30 minutes each to present their submissions. We will now invite the first oralist to begin their submission.
Thank you, Bailiff. Before I begin, can I confirm with the members of the panel that I'm audible and you can see me clearly? Thank you, members of the panel. Good morning, members of the panel. My name is Austin Seah, and I'll be speaking on behalf of the first appellant, Mr. Landed, on the first issue regarding GDC's quorum and the fourth issue on doping for 15 minutes. My co-counsel, Mr. Mark Maxwell Peter, will be speaking on behalf of the second appellant, Ms. Tangs. He will address issue 2 on the location of the tribunal and issue 3 on Ms. Tangs' ability to participate in the qualifying games for 14 minutes. We respectfully reserve 1 minute for a rebuttal. Members of the panel, this case concerns ensuring fairness and addressing the issues of potential biasness. The gold medal belongs to Mr. Landed, who earned it through his performance leading his team's comeback in the finals of the qualifying games. However, the tribunal that reviewed the matter appeared to have a majority inclined towards Ms. Tangs. Given these circumstances, the law supports the medal's return. Failing to do so could undermine the protections and fairness that athletes are entitled to. With that, I make 2 submissions regarding the first and fourth issue. Firstly, the Games Disciplinary Committee, hereinafter the GDC's quorum, was biased in coming to a decision. Mr. Douglas and Ms. Farina are not independent and impartial arbitrators of the GDC's quorum. Secondly, the GDC had erred in finding that Mr. Landed had been liable for doping. Bluebat is not inside the World Anti-Doping List, and Mr. Landed is hence not liable for doping. Turning to the first issue, to determine the criteria of an arbitrator, the applicable rule is Rule 33 from the CAS Code. Rule 33 states that, and I quote, "Every arbitrator shall be and remain impartial and independent of the parties and shall immediately disclose any circumstances which may affect his or her independence with respect to any of the parties." This proposition is similarly found in exact wording in the Malaysian Arbitration Act at Section 13.8 Part B, which reads, and I quote, "In appointing an arbitrator, the director of the Asian International Arbitration Centre or the High Court, as the case may be, shall have due regard to other considerations that are likely to secure the appointment of an independent and impartial arbitrator." As noted in both wording of Rule 33 and Section 13.8b of the Malaysian Arbitration Act, the criteria of an arbitrator requires both impartiality and independence. As long as one of these criteria are not met, this will demonstrate that an arbitrator is biased. Firstly, we argue that there was a lack of independence on both parts of Ms. Farina and Mr. Douglas. To determine what amounts to an independent arbitrator, we can look to case law. In the 2006 case of FCV and NF at para 5, the court noted that strong or negative emotional bonds through relations between the arbitrator and one of its party or counsel may indicate a lack of independence. This proposition is similarly upheld in the 2000 Swiss Federal Tribunal case of Sadi Center Constructions at paragraph 3. Applying these principles to our cases, we will turn first to Ms. Farina. In our case, there are two types of relationships that she has with Ms. Tangs. If I could direct the panel's attention first to para 4 of the record. She is Ms. Tang's cousin sister, showing that Ms. Farina has a familiar relationship with Ms. Tangs. Essentially, Ms. Tangs is Ms. Farina's cousin, showing a personal relationship between both parties. This kind of personal connection could easily be characterized as a strong emotional bond between family members, which can indicate impartiality on the part of an arbitrator. If I could then turn the panel's attention to the very same paragraph, it is noted that Ms. Farina had also provided extra on-the-side coaching to Ms. Tang's team and prepared them for the upcoming qualifying games. This demonstrates a professional relationship where Ms. Farina had invested time and effort into Ms. Tang's success prior to adjudicating on the dispute involving her. With both a professional and personal relationship, it can be inferred that Ms. Farina and Ms. Tangs possess strong emotional bonds. Turning next to Mr. Douglas, if I could first turn the tribunal's attention to para 26 of the record. If the arbitrators are with me. 6 months prior to the events of the case, he was engaged to have a one-time special and personal sharing session for Ms. Tang's team. This shows professional support for Ms. Tang's team. Following that session, in the very same paragraph of the record, the relationship eventually got closer, with both parties being in contact for the last 6 months. This ongoing contact and close relationship constitutes a continuing positive bond extending beyond a single professional engagement. This is further bolstered by the fact that Mr. Douglas has participated with Ms. Tangs in fan meetups as seen in the very same paragraph of the record. Going beyond a simple role as a coach, this public association further solidifies the factual existence of a positive and strong bond that lasted 6 months till the very date of the hearing. In fact, members of the panel, there does not need to be an actual finding of biasness or a lack of independence in our cases. Rather, it suffices that an arbitrator, based on the circumstances relating to the arbitration, to be objectively viewed as such. This is known more frequently as the apparent bias. This proposition was laid out at paragraph 7.4 in the 2020 Swiss Federal Tribunal case of Sanyang and World Anti-Doping Agency, and further solidified by the IBA guidelines of conflicts of interest in international arbitration at section 2B, where the relevant portion reads, and I quote, "From the point of view of a reasonable third person having knowledge of the relevant facts and circumstances, that would give rise to doubts as to the arbitrator's impartiality or independence." In our case, we acknowledge, or we would concede with the respondent, that there was no evidence of any actual bias. However, the necessary inference from the facts that I brought up prior to this arises from the objective reasonable third party. If I could turn the panel to para 26 of the record. The GDC's quorum is a tribunal operating with 2/3 of its quorum, maintaining personal, documented, familial, and professional bonds with Ms. Tangs, the party contesting the results. They cannot objectively be viewed as independent in their adverse ruling against Mr. Landert as seen at para 33 of the record. Simply put, the presence of a familiar relationship between Ms. Tangs and Ms. Farina, coupled with a close extended personal relationship between Mr. Douglas and Ms. Tangs, is sufficient for apologies, Madam Arbitrator. You had a question?
Yes, thank you, Mr. Seah, for being so observant. I just wanted to check Given the results, the outcome or the decision by the GDC, which is neither in favor of Mr. Landed nor Ms. Thanks, would the issue of bias still be in place?
Certainly, Madam Arbitrator. The alleged bias was actually successful in its primary objective, which is to ensure that Mr. Landed had lost his gold medal by ruling against him on the doping issue. The fact that the panel later found Ms. Thanks ineligible on an unrelated legal technicality, such as nationality, does not undo the perceived bias that determined the outcome of the doping case against Mr. Landed. Essentially, both cases have to be seen separate on its merits. In conclusion, we submit that Ms. Farina and Mr. Douglas are biased members of the GDC's quorum. Unless I may be of further assistance on the first issue, I'll turn to the fourth issue regarding doping. Our submission for the fourth issue is structured into three main arguments. Firstly, Rule 12 of the qualifying game rules should not be applied as it is overly broad and inconsistent with the WADA code, and a finding of a doping violation under the GDC's own rules is unfounded. Secondly, bluebat is not a prohibited substance under the WADA code, and liability cannot attach to unlisted substances. And lastly, the GDC's enforcement of the anti-doping rules violated the principles of legality, due process, and legitimate expectation due to the lack of clear notice. Turning to our first argument, the WADA code is the exclusive standard for doping violations. While the respondent may seek to rely on Rule 12 of the qualifying game rules to find that Mr. Landed had committed a doping violation, reliance on Rule 12 itself is wrong. Rules 7 to 13 of the qualifying game rules clearly provide that doping is defined by reference to the WADA code and the prohibited list. Rule 7 defines doping as, and I quote, occurrence of one or more anti-doping rule violations set forth in the WADA code, WADA prohibited list and the WADA code. And Rule 13 instructs athletes to, and I quote, refer to the WADA prohibited list for the list of prohibited substances. Accordingly, this shows that the WADA code forms the exclusive and mandatory benchmark for determining anti-doping violations. Furthermore, Rule 12 is inconsistent and too broad and should not be applicable in our case. Notably, this a broad rule regarding a violation of a doping, panel. A violation of a doping violation of a doping is essentially a rule regarding violation of doping that is too broad has been overruled by the CAS in multiple occasions. In the 2004 CAS case of Maria Louis Kelly Williams and IOC, the panel noted that a catch-all provision of other chemical substances with similar chemical nature cannot be construed to mean every stimulant, which is precisely what Rule 12 of the qualifying games seek to do. At para 25 of that case, it was noted that such interpretation will not pass the test of clarity and predictability. They further brought in examples of other stimulants such as nicotine and caffeine, which all fall under the interpretation of Rule 12, and yet, crucially, are not banned by the WADA prohibited list. Therefore, an extremely restrictive approach must be taken in interpreting Rule 12, which should be read together with WADA guidelines, which is precisely what Rule 13 of the qualifying game rules has noted. Furthermore, CAS jurisprudence has confirmed that sporting bodies cannot expand doping rules. In the 2011 CAS case of USOC and IOC, the IOC's attempt to impose additional sanctions beyond the WADA code was held invalid because the Olympic Charter had already made the code mandatory. Therefore, Rule 12 of the qualifying game rules should not be followed, and the finding of a doping violation under the qualifying game rules is incorrect. Secondly, bluebat is not a prohibited substance under the WADA code, and liability will only arise for listed substances. And this has been upheld in multiple CAS decisions, such as in the 2006 CAS case of Butera and ITF, 2008 CAS case of ITF and Gasquet, and 2016 case of Sharapova and ITF. Secondly, even if bluebat did bear similarity with any known prohibited substances, it does not meet the threshold as required in the 2004 CAS case of Maria Kelly Williams and IOC. Notably, the panel held that an unlisted substance may only be banned if it has a similar chemical structure and pharmacological effect to a listed stimulant, and finding no such similarity, the CAS ruled that no violation had occurred. In our
Yes,
case,
Mr. Seah, but in our situation, the tests have not been concluded as yet, right? So we can't really rely on that case that you seek to rely on, because obviously in that case, I think there is already a conclusion, right? In terms of the breakdown of the prohibited substance or the substance in question.
yes, Madam Arbitrator, and this brings me to my next point on the essential point of burden of proof. In our case, it was in the Maria Kelly Williams case, it was the CAS burden of proof to show that a doping violation had occurred. And presently, in our case, we do not have enough facts to show whether Bluebat indeed bears such similarity as noted by Madam Arbitrator. But the burden of proof in our case falls on the GDC to prove so. And in that case, isometapine was initially considered to not be a stimulant, and subsequent detailed medical research ordered by the court did find that it was considered a prohibited substance. Therefore, it would be presumptuous for this court to jump the gun and find that Mr. Landert had breached the WADA code without first precisely examining the chemical nature of Bluebat and addressing that submission. And therefore, the GDC had erred in finding that Mr. Landert had committed a doping violation. Madam Arbitrator and members of the panel, I note that my time is about to elapse. If I may have 2 minutes to quickly wrap up on my last submission. Thank you. Lastly, we argue that athletes must have a clear and predictable notice of prohibited conduct. The principle of legality requires that sanctions be based on clear, accessible, and foreseeable rules, and punishing conduct where regulatory guidelines are absent or ambiguous violates both due process and legitimate expectation, and this is upheld in the 1995 CAS case of Quigley and UIT. In that case, the athlete had ingested cough syrup containing ephedrine after being told by a doctor that it was safe. And although strict liability applied, the CAS held that the rules in that case was insufficiently clear to justify disqualification, emphasizing that unclear bans offends the principle of legality and therefore overturning the finding of a doping violation.
Understand. But I just have one question. I mean, the GDC did say that they did look at things factually, and they looked at how his own team's overall performance. His teammates could not even stay as focused as he did. So I think there is this factual element here, I think, which you've not yet addressed.
Certainly, Madam President. Looking at the context of Mr. Landert and experience without player, it could simply be said that he was just better at the game and he was more focused throughout his other teammates. Notably, at many junctures of the game, he was considered to be an MVP, as noted inside the record at paragraph 6, if I may direct the panel's attention to that.
Sorry, at paragraph?
At paragraph 6 of the record, Madam Arbitrator.
Okay.
Being the leader for this tournament, he has been carrying his team throughout and has won multiple draw-breaking games. And notably, in the very same scenario that we're faced with here, if he's able to carry them throughout other draw-breaking games, it could be said that he just simply possessed the same amount of attention and focus that managed to allow him to win the competition in the end. I note that my time has elapsed, and unless I may be of further assistance to the panel.
Not for me. Thank you very much, Mr. Seah.
This concludes my submissions. Thank you. I'll now hand over my time to Mr. Mark Maxwell Peter, who will address the remaining 2 issues. Thank you.
Good morning, Mr. President, members of the tribunal. As introduced earlier, my name is Mark Maxwell Peter, appearing for the appellant Ms. Tanks. I will speak for 14 minutes. I will be making 2 submissions in this hearing. The first submission is whether GDC erred in convening the disciplinary tribunal in South Nangkalan. Mr. President, I will structure my submissions in 2 parts. First, the legal frameworks, namely the Malaysian Arbitration Act 2005 and the qualifying game rules, and second, the relevant authorities and how they apply to the record before this tribunal to demonstrate why the tribunal in South Nangkalan cannot stand. Mr. President and the members of the tribunal, The governing law of this arbitration is Malaysian law as clarified in paragraph 42 of the clarifications. Section 22 of the Malaysian Arbitration Act provides, and I quote, where the parties fail to agree, the seat shall be determined having regard to the circumstances of the case, including the convenience of the parties. Mr. President, I here refer to the seat in a practical sense and the physical venue where the tribunal was convened, since the procedural law, which is a Malaysian law, has already been settled in the clarifications. In this case, the hearing was held in Global Games headquarters in South Nangkalan, an oceanic country, despite Ms. Tang's expressed disagreement that the location was unsuitable for her. If the panel would turn with me to page 25 of the record, we will see that the riots in Rambutan subsided within 3 days. Yet the tribunal was convened a week later in a different location. The circumstances therefore no longer justified moving the hearing away from Rambutan. Turning to paragraph 29 of the record panel, the athletes were not consulted before the change of the venue, and Ms. Tang specifically objected, stating that the location was not suitable for her. Section 22 requires two limbs, circumstances and convenience, to be satisfied. The GDC failed both in this scenario. The circumstances was no longer warranted a relocation, and athletes' convenience was completely ignored. In addition, Rule 23 subsection 1 of the qualifying game rules provide, and I quote, an internal tribunal shall be convened in a country where the tournament was held where reasonably practicable. This safeguards ensures hearing occur near the competition site and in an environment equally accessible to all the participants. As shown at paragraph 25, it was practicable to hold the hearing in Rambutan itself. By relocating the tribunal to South Nangkalan, the Federation's own headquarters, the GDC disregarded both Section 22 of the Malaysian Arbitration Act and Rule 23 of the qualifying game rules of the qualifying game rules. This interpretation aligns with the 1997 Federal Court case of R. Ramachandra and Industrial Court of Malaysia at paragraph 1, where the court held that any decision tainted by procedural unfairness or bias is held invalid. The GDC's relocation thus violated the domestic legal framework and the principles of lex sportiva, which demands the disciplinary body act impartially and avoid even the appearance of home court advantage. Now, I would like to refer to the case of the 2018 case of Muthu Peshin and Switzerland at paragraph 139 to 143. The courts explained that impartiality must both satisfy the subjective and an objective test, namely whether the reasonable observer would perceive the tribunal as independent. Applying the principle here, the tribunal held in South Nangkalan creates an appearance of partiality, namely because the GDC is institutionally tied to the organizing structure of global games. The local law, administrative staff. Yes, Madam.
No, please just continue.
Thank you. The local law, administrative staff, and the facilities belong to the same federation overseeing the disciplinary process, and the procedural familiarity and the logistical advantages favor the respondent and places athletes at a disadvantage. And finally, in the 2010 case of CAS, CAS case of SC Sporting and Ljubovic, at paragraph 33 to 39, we see that the CAS panel reaffirmed that only an independent arbitration tribunal guaranteeing fair proceedings and equal representation of both sides qualifies as a legitimate forum under the FIFA regulations. This case demonstrated that even structural or institutional ties without the proof of actual bias are sufficient to undermine the appearance of impartiality. Mr. President, members of the tribunal, for these very reasons, the appellant submits that the GDC's tribunal was improperly convened in South Nangkalan, and we pray that it be reconvened in accordance with the Malaysian Arbitration Act and the principles of lex sportiva, because only a truly neutral venue can guarantee independence, transparency, and fairness owed to every athlete. Now, I'll be moving on to the second issue, which relates to whether the GDC erred in declaring Ms. Tanks ineligible to participate in the qualifying games. We submit that the GDC acted ultra-vires and in violation of both the qualifying games rules and lex sportiva. The GDC misinterpreted Rule 3 of the qualifying game rules by rewriting the standard of eligibility to require 100% Asian citizenship, thereby acting discriminatory and beyond its powers. Rule 3 subsection 1 provides, and I quote, "A person is eligible to be a participating athlete if he or she is a citizen or a permanent resident of a country in Asia." We can see here that the language is clear. It sets out two distinctive categories, which are the citizenship or a permanent residence. And there is no mention of an exclusive 100% Asian citizenship or a restrictive test of purity of nationality. And any attempts by the GDC to narrow down this rule departs from the factual text and violates the principles of legality and fairness under Lex Sportiva. Now, if the panel would turn with me to paragraph 33B of the record. The GDC held that Ms. Tanks was, and I quote, "not 100% Asian citizen and therefore ineligible to participate." However, the additional requirement does not exist anywhere in the rules, and in doing so, GDC exceeded its interpretative powers and acted as a rule maker rather than a rule interpretator. In the 2000 CAS case of ANTS and Norwegian Wrestling Federation at paragraph 18, the panel held that when rules are ambiguous, they must be interpreted contra perforentum, which means against the drafting bodies, which is in this case the Sporting Federation. Similarly, in the 1991 CAS case of G and Federation Equestrian International at para 7, the panel reiterated that unclear regulations must not prejudice athletes who rely on the published text. Applying these principles, any doubts in Rule 3 must be construed in favor of the athlete and not against her. Moreover, in the 2009 case of Telecom Egypt Club and Egyptian Football Association at paragraph 33, the panel held, and I quote, "CAS cannot rewrite but can only interpret rules set forth by the sport authorities in light of the general principles of law." Thereby, the GDC, by adding an unwritten requirement of sole nationality, effectively rewrote Rule 3 and thereby acted ultra vires, all beyond its powers. And lastly, the 1994 CAS case of Puerto Rico Amateur Football Federation and the United States America Baseball at paragraph 1 and 2, the panel reaffirmed that each country has a sovereign right to determine its own nationality law, and at page 9, the panel held that the athlete with dual nationality may freely choose which country they wish to represent, provided that they have not represented another country in the past. This approach is consistent with Rule 41, Bylaw 2 of the 2025 Olympic Charter, which expressly recognizes that a competitor who is a national of two or more countries may elect which country he or she may wish to represent. By applying these authorities to the record, Ms. Tanks satisfies every requirement of Rule 3, subsection 1 in accordance with Rule 41, Bylaw 2 of the 2025 Olympic Charter. Her citizenship was validly conferred by Dorania's sovereign law, and she submitted a documentary proof of her domicile status as noted on paragraph 32 of the record. Under the case of Puerto Rico Baseball Federation and the 2025 Olympic Charter, she therefore had the right to represent Dorania, and the GDC's decision to disregard her lawful citizenship and demand 100% citizenship 100% Asian origin was contrary to Lex Sportiva and the principles of equality in sports. And under ANS and Telecom Egypt, any uncertainty in Rule 3 must be resolved against the rulemaker, who is in this case the qualifying game rules committee, and not against the athlete, who is Ms. Tanks. Finally, the GDC's approach undermines the consistency and fairness that are fundamental to Lex Sportiva. As stated in the 1998 CAS case of AEK Athens and UEFA at para 156, and I quote, "Sports law has developed and consolidated particularly through the arbitral settlements of disputes, a set of unwritten legal principles, a sort of lex mercatoria for sports, or to speak lex ludica, which is a national and international sport federation, which the National and International Sport Federation must conform to. The GDC's discriminatory reading of Rule 3 departs from the very uniform and predictability standards, and if dual citizens are excluded based on the vague notions of ethnic purity, the integrity and the inclusivity of the international competitions would be seriously compromised. Mr. President and the members of the tribunal, Ms. Tanks satisfies Rule 3, subsection 1. She is a recognized citizen of an Asian state, Durrania, and has never represented any other nation. And under the Olympic Charter, she is free to elect her allegiance. By imposing additional and discriminatory requirements of 100% Asian citizenship, and the GDC exceeded its powers and acted beyond its powers. Now, Mr. President and members of the tribunal, both the issues strike at the very heart of the fairness in sport. First, the GDC's decision to convene proceedings in South Nagaland, its own headquarters, undermine neutrality and procedural fairness. And second, on the eligibility, GDC exceeded its authority by rewriting Rule 3 to 100% Asian citizenship. The CAS jurisprudence makes it clear that the sporting bodies interpret and don't invent rules from scratch. Thus, we respectfully pray that the panel declare South Nagaland Tribunal invalid and affirm that Ms. Tang's eligibility and restore fairness, neutrality, integrity owed to all the athletes. Unless I can be of any further assistance, I would like to
Counsel, just a question on one of the points you raised earlier.
Yes, Mr. President.
So, in essence, what legal significance would you attach to the seat of the tribunal under the CAS code? In your view, does the improper designation of the hearing location affect the validity of the proceedings, or would it be raised merely as an issue of procedural fairness?
Mr. President, the issue of the physical location of the seat itself raises impartiality and biasness. Here we see, Mr. President, we are talking about the seat in a practical sense, and the venue, since lex arbitrary and the Malaysian law is already fixed in the clarifications. And since Ms. Tanks had vocalized her uncertainty and not wanting the tribunal to be held in a different nation, it was apparent by the facts that Ms. Tanks did not consult to the change of location, and there was no consultation prior to the change of location itself, but rather they were just given a notice that the next tribunal would be held in South Nagaland rather than Rambutana itself. So in essence, the athletes were not giving any opportunity to raise their opinions, nor they were consulted before such move. If I can do.
Also, I do have one question. If Mr. Asil is satisfied with the answer, okay. Is there anywhere in the facts that say the reason why Ms. Tanks disagreed to the location?
No, Madam President. The facts does not specifically state that she did not specifically state the reason, but she was just not comfortable, and is only stated in the facts at paragraph 25 that she was not comfortable with the location.
Sorry, paragraph?
At paragraph 29, Madam President. Apologies. Madam Arbitrator.
Okay. Okay, thank you.
This concludes my submission. Thank you very much, Mr. President, and the members of the tribunal.
No. Bro, you freaking say Madam President, bro. Jeez, wait, you fucking go damn fast also. Relax, Jesus.
Fuck, I fucked up with the Madam President.
You didn't answer his question also.
Yeah.
Good morning, members of the tribunal. My name is Fu Kai Chong, appearing for the respondent, the Game Disciplinary Committee. We'll be allocating 40 minutes for issue A and issue D. Mr. Arbitrator and Madam Arbitrator, there are only so many fishes in the sea. in a tight community like sports and co-dog, people would eventually know each another. But that does not mean it automatically results in a presumption of bias. Now, I'll firstly address on issue A on biasness. The appellant made two arguments. First, the quorum is biased, and second, non-disclosure is fatal. Respectfully, we disagree. Our stance is that neither of the arbitrators are biased, and we have 3 points in response. Firstly, the outcome shows that the tribunal is indeed not biased. Second, the threshold for apparent bias has not been met. And lastly, non-disclosure is not fatal. Now, turning to our first argument on the outcome. The appellant submitted that outcome does not matter in the apparent bias test. However, based on the case of Ulrich, when applying the apparent bias test, we asked the question of whether a reasonable third person considered all of the facts would conclude that the arbitrator is biased. Members of the tribunal, considering all the facts, this includes whether the relationship affected the outcome. This is because this is the first time that the arbitrator's partiality is challenged after the decision has been made. And in those cases of apparent bias, it is before the decision has been made. Therefore, we should take into consideration of the outcome. And what is the outcome? As rightly pointed out by Ms. Chai just now, the tribunal have ruled both Mr. Lambert and Ms. Tang's liable under paragraph 33. This shows that the tribunal applied its mind objectively to the evidence witnessed and concluded that both parties should be found liable and ineligible. Now, the appellant's entire premise of the appellant submission is based that the panel is too close with Ms. Tang's. However, if they were as close friends or too close to Ms. Tang as alleged, Ms. Tang's would not be disqualified and she would be the champion. The results in the GDC says otherwise, and this is sufficient to rebut the bias allegations. However, turning to our second point, if we disregard the outcome, the threshold for apparent bias test has not been met. This is for two reasons. First, those cases cited by the appellant arises from a broader settings, commercial arbitration. However, in sports arbitration like this, our case concerns only a few committees that are experts. And in the case of Alejandro, in such niches, overlaps are common. There are only multiple people that are well versed with the rules of conduct. The logic is very simple. There are only so many fishes in the sea. And in a small pond, knowing one of the fishes does not make you biased. Firstly, I will address on Ms. Farina, then Mr. Douglas. On Ms. Farina, the appellant emphasized they are family, cousin sisters. However, that alone does not make the relationship dangerous. This is because under the International Bar Association, guidelines for conflict of interest of arbitrators, they specify close family here only refers to family members like mother, father, children, or direct siblings. Cousins are not listed as direct unless they are living under the same roof. The key is whether that it materially affected the outcome. Secondly, the appellant submitted that Ms. Farina is a coach. However, if I may refer the tribunal to move paragraph 4, let's have a close reading of it and it will tell a different story. On line 2, on the first line, it says Ms. Tang has asked for help. And if we refer to page 3, it only said that Ms. Farina was asked to guide Ms. Tang's team. Nowhere in the MOOC problem said that she answered to the coaching request by Ms. Farina.
Counsel, could you please elaborate which paragraph you're referring to, rather than the page number?
Paragraph 4, the first line, and the third line.
Thank you.
Yes, so here it mentioned only he had asked and had requested. There's no showing that he has answered this request and she is formally a coach. However, if we do take the appellant's submission that she indeed was a coach, which is an inference, we should focus on her scope of her work. Members of the tribunal, not every coach is the same. Here, Ms. Farina is recruited for her knowledge of the game, which is like a technical advisor, not a gameplay coach, and not for this dispute. This is similar to sports like figure skating or the NFL, where there is technical advisors to look through the videos to find whether the team is in accordance with rules. Therefore, we submit that Ms. Farina's guidance, at best, was limited, general, and way earlier in time. Therefore, this is too remote to satisfy the apparent bias test. Now, turning to Mr. Douglas, the appellant raised a huge suspicion based on the assumption of paragraph 26 of the moot problem. Here, in reality, it is a small pool of people, a small pool of experts. It is expected for sports celebrities and a streamer to cross paths in fan meetups or in events like this. Mr. Douglas merely had one sharing session months before, and it's towards the whole team, not just Ms. Farina, and they remain public contact after. Members of the tribunal, we also acknowledge that the moot problem did not specify what is the frequency of their contact, and getting closer here is subjective. Therefore, Mr. Douglas does not fulfill the apparent bias test as well. Now, turning to our last argument on the non-disclosure, the appellant argues that non-disclosure is fatal. Respectfully, that is not the law. The Swiss Federal Tribunal held that non-disclosure asks the reasonable question as well. Would a reasonable third person, knowing all the facts, would have legitimate doubts on whether the arbitrator is hiding something? The exact words used here is deliberate concealment. However, here the context were public and known. Ms. Farina's relationship with Ms. Tang's is known, and at the end of the day, the tribunal still reached a mixed outcome, finding Ms. Tang's, her cousin, disqualified, which undermines the theory of any biasness. Therefore, we also submit that non-disclosure does not invalidate the decision.
Counsel, if I may just stop you there. Can you please direct me to where in the moot problem it says that their relationship is known? Because if I'm not mistaken, paragraph 27 only says that it is Ms. Farina's assumption that their relationship was public information.
Madam Arbitrator, that is precise. It is under paragraph 27 that she said that it is public information. However, we say that this is not an assumption, and based on the case of the Swiss Federal Tribunal, the courts would look at whether there is deliberate concealment from the party. And in this case, Ms. Farina did not deliberately conceal it. She merely did not disclose it because she thought that it was public information. Furthermore, there is also a duty of curiosity, which is held by the case of Sun Yang, where the counsels of the parties, which is Mr. Lander's lawyer, should have the due diligence to find out whether there is any challengeable grounds for Ms. Farina. However, these are not done, and there was no challenge of the arbitrator's impartiality during the GDC stage.
Okay, counsel, then what do you have to say about Rule 33 of the code saying that the arbitrator shall immediately disclose any circumstance which may affect her or his independence?
Madam Arbitrator, that is a precise observation. However, the Swiss Federal Tribunal also acknowledges this. They say that they will look into the arbitrator's mind from a reasonable third person whether she feels that it is needed to disclose this such information. And when it comes to a small community like this, everyone knows that they are cousins. Therefore, there is no need to disclose this relationship. Now, unless I can further assist on the issue on bias, I'll now turn to issue 4 on doping. Members of the tribunal, the appellant submitted that blue bet is not prohibited for two reasons. First, Rule 12 of the game rule should not be applied because it is not in accordance with WADA. And second, the clause is too broad. However, we reply with two arguments. Firstly, blue bet falls under Rule 12 of the game qualifying rules. And second, the appellant failed the due diligence threshold for an athlete. Now, turning to the first argument on Rule 12, and if I may invite the tribunal to Rule 12 of the qualifying rules. Members of the tribunal, today's decision rests on the interpretation of Rule 12. The appellant submitted that is too broad, and whether blue bet falls under contrary to the spirit of sport. So, how do we interpret spirit of sport? The respondent submits that it must capture a prohibited substance that has yet to be listed. Now, if I may refer the tribunal to the WADA prohibited list 2025, page 40, and it says here, I quote in verbatim, "and other substance with similar biological effects shall be deemed as a stimulant." Meaning to say, Madam and Mr. Arbitrator, Section 6B of the WADA list is an open list. It is not a closed list, and it is not limited to express leading. Meaning to say that blue bet must not be explicitly listed in the list. It can fall under other substance that is with similar biological effect. Now, the case at hand today is exactly the same as the case of Jane Sturba. The tribunal held a drug, which is called BM, even though unlisted explicitly in Section 6, is still prohibited for falling into this open list stimulant, Section 6, for one reason, because it increased the alertness of Mr. Sturba. This case shows us that blue bet does not be explicitly listed to be banned. As long as it is similar to a stimulant, it is banned. And here we submit that blue bet's biological effect is very similar to modafinil. Both drugs here have the same biological effect for two reasons. First, it enhances concentration under paragraph 16 of the mood problem. And second, both are commonly misused in the workplace for extended attention span. As rightly pointed out by Ms. Chin just now, this shows that it is banned, and furthermore, other teammates have failed to perform to the standard of Mr. Lander. It shows that blue bet in nature is a cognitive enhancer, and merely does not falling under the list does not make it not banned. Why? The logic is very simple. WADA could not possibly list every drug in existence. There is new drugs coming up every day. That is why the WADA list includes an open list mechanism to prevent athletes from exploiting new drugs like a loophole. And an athlete like Mr. Lander could not use this loophole to gain an unfair advantage. Members of the tribunal, I see my time has left. If I may request 1 minute to sum up my last argument. Thank you. Turning to my last argument, we submit that athletes must avoid substance which they are unsure of, and asking does not mean completed duty. Now, when ambiguous exists, the rule is clear. Refrain from consuming blue bet and seek clearance before consuming it. Now, the appellant shown in the mood problem state that he asked the medical staff in paragraph 30. However, Mr. Lander asked the wrong person, got a maybe, and acted wrongly on a maybe. The medical team here was the team medical staff, not the game medical staff, which is the wrong party. First crucial point. Second crucial point, let's look at what the medical staff said in paragraph 30. They merely said that it is uncertain and it is not on any official bulletin in paragraph 30, line 4. This is a maybe, an uncertainty, and a maybe is not a yes. Only an unequivocal clearance saying that blue bet is safe is a yes. However, this is absence in our case. I'm sure it's not a justification And if uncertainty could be used by any athlete as an excuse, every athlete will claim it. To conclude, blue bet is captured under Rule 12 in accordance with the WADA list, and the athlete fell short in exercising due diligence.
All right, Mr. Fu, question. You mentioned that Mr. Landed did ask for clearance before he consumed it. Is that what you mentioned? Where can I find this?
Paragraph 30, line 3, where he
30?
said, yeah, 30.
Furnish emails from team medical staff indicating uncertainty, is it?
Yes.
Oh, so he didn't consult any medical team before he consumed it now?
Yeah, and it's not the game disciplinary medical staff, and it's also just a maybe answer, and he's still consuming.
Sorry, where were you getting this?
Madam Arbitrator, in paragraph 30, it says
30?
that, yeah, 30. The emails published during the hearing is whether he asked the team medical staff on whether the product is prohibited. However, they merely replied it is uncertain.
Okay, but you're not able to gauge from here exactly when he asked the team medical staff now?
That's true, Madam Arbitrator. However, if he asked before consuming it, it would be the wrong person and the wrong answer to consume it. If he asked after consuming blue bat, it will show that he didn't exercise any due diligence at all.
Yeah.
If there's no further questions from this tribunal,
Counsel, I do have one additional. At paragraph 29, it does state that Mr. Landed has not read the qualifying game rules. So do you have any submissions on the fact that maybe he had no knowledge at all, that he has no obligation to ensure that he wasn't consuming any substances?
sorry, Madam Arbitrator, may I clarify on paragraph 29?
Yes. So it does say that he did not contest the location, but it also says that he had not read the qualifying games rules. So wouldn't that mean that he was not aware of this anti-doping rule and that he had a responsibility to ensure that he wasn't taking in any prohibited substances?
Madam Arbitrator, excellent observation. However, if we read the qualifying game rules, Rule 10, and also the WADA list, it is actually strict liability. Athletes must be responsible for any substance in their body. It doesn't matter if they don't have the intention, it doesn't matter if they are careless, it doesn't matter even if they don't read the rules. They failed as an athlete to prevent any prohibited substance from entering their body. And we submit that the athlete, Mr. Landed, has a duty to read the rules, go in accordance with the rules, and prevent any substance like blue bat from entering his body. If I may be no further assistance to this tribunal, I'll now pass it on to my co-counsel, Ms. Ashley. Thank you.
Members of the tribunal, am I audible? Good morning, members of the tribunal. My name is Ashley Lee, representing the respondent, the Game Disciplinary Committee, GDC. I will address issue B and issue C, and I respectfully reserve 14 minutes for my submissions. Members of the tribunal, let's put ourselves in the shoes of the respondent. Imagine a house is on fire, and the appellant insists that the respondent stay inside simply because that was the original plan. And that is precisely what the appellant is asking this tribunal to do today. And with that, it brings us to issue B, which concerns the relocation of hearing to South Nakalet. Members of the tribunal, the appellant argued that relocation is not allowed for 3 reasons. First, Rule 23 does not allow relocation. Second, the riot subsided in 3 days. And third, Ms. Hanks was not consulted. And respectfully, we disagree. Our stance is that the respondent is allowed to relocate the hearing, and I have 3 points. First, Rule 23 does allow relocation. Second, there is a massive riot. And third, Ms. Tam's reason of objection is insufficient. And with that, it brings us to the first point, which we submit that Rule 23 allows relocation. And I would like to refer the tribunal to the clause of the dispute, which is in the qualifying game rules, page 6, Rule 23, specifically clause 2. Is the tribunal with me? Thank you. And the general rule of this Rule 23 is the parties are to set out the hearing in the country of the tournament. This we do not dispute. However, there is an exception, and the exception is relocation is allowed when it is not reasonably practicable to do so. And now, the appellant argued that this exception did not apply. However, we submit that this is wrong, and I will lay down the correct threshold and how this threshold had been met. First, on the threshold, Mr. Arbitrator, the appellant had relied on different cases and Malaysian arbitration law, which are all decided under the UNCITRA model. However, in all those cases, the UNCITRA model is silent on whether relocation is permitted. And so, in that situation, the tribunal had to apply contractual doctrines such as force majeure, fundamental change, those extreme circumstances. And this is why, in those cases, the threshold is extremely high. And rare. And however, this is not the case here. Because our case is different, the rule is special. It expressly provides an exception to relocate, and it gives the respondent the sole discretion to invoke the exception. And for this, I would like to refer the tribunal to clarifications number 16. Which it states that the GDC has the final say when the party disagree about the location of hearing. And as such, on a threshold of comfortable satisfaction by the GDC, the GDC can relocate when it is determined that it is not reasonably practicable to host the hearing in Rambutana. And we would like to draw parallel to the case of Football Club Wallen Last in P 2014, which in this case, the agreed hearing venue was initially set in Ukraine. However, due to political unrest and security concerns, the tribunal moved the hearing to the headquarters in Lausanne. And this is very similar in our case, and I will invite the tribunal to moot problem Para 25. Which I quote, a day after the tournament, there were massive riots against the government, and I emphasize, massive riots against government. Massive means large scale, and riot means violent public disturbance. Also, therefore, the massive riots here today are not only against any private entity, but it is an anti-government riot that destabilized the entire country.
You really want to rebut?
No, I'm just taking
And the
notes.
riots can render the hearing in Rambutana
Yeah.
dangerous, as it raised serious concerns regarding the party's safety. And moving on to the second point, the appellant argued that the riots had subsided in 3 days, and therefore the hearing can still be conducted in Rambutana within the 1 week period. However, respectfully, we submit that this is wrong. Mr. Arbitrator and Madam Arbitrator, GDC is not a fortune teller. We are not a time traveler. And at that time of situation, there's no way for GDC to foresee or even to predict when such large-scale riots will end. And time is an essence. a timely relocation is very important because the request of internal hearing is done and the riot started. The preparation needs to start on the spot. The location needs to be determined quickly. And to emphasize, the word subsided means less intense. It does not mean completely safe. And since we are unable to foresee when the riots will end, when will it be completely safe, therefore, the only options to relocate the hearing to somewhere safer and neutral, which is
Gary,
in
to help me
the
on mute.
headquarters
Gary,
in
to help me on
Thailand.
mute.
And moving on to the third point, the respondents submit that Ms. Tang's reason for inconvenience is insufficient law. The appellant argued that Ms. Tang is not consulted, the reason of her objection is not provided, and she's disadvantaged. However, this is wrong. As rightly pointed out by Madam Elena, the only reason for Ms. Tang's objection is provided in Moot Problem Para 29, which we quote, Ms. Tang's disagreement that the location would not be suitable for her. And therefore, it is clear that the underlying rationale is the relocation is a mere inconvenience to Ms. Tang's. And this is why the respondent had rejected her objection. As in case jurisprudence, mere inconvenience is never insufficient to invalidate a relocation. And to draw illustration, in the case of W and UK Athletes 2003, the panel held that personal inconvenience did not amount to procedural unfairness, and decision could not be annulled on that basis. And the question now shifts to what is a suitable reason to annul an award? And the only suitable reason to annul an award is when an individual will be prejudiced, when Ms. Tang is prejudiced. However, this is not the case here, as Ms. Tang is not prejudiced anywhere. It is because 1. She's able to fully participate in the hearing. 2. She's able to handle all the evidence. And 3. She's able to fully argue her case. And hence, having participated in the hearing itself and suffer no prejudice, she cannot not turn out and simply seek to annul the decision. And to add on, any inconvenience suffered by her can be compensated by cost, but it does not justify the annulment of the decision. And members of the tribunal, if there are no questions by the panel.
Sorry, Counsel, I do have one question. I believe one of the appellant's arguments was that no notice was given about the location of the hearing. Do you have any submissions on that?
Mr. Arbitrator, please give me a moment, Madam Arbitrator. Madam Arbitrator, we submit that this is wrong, as I will lead Madam Arbitrator to clarifications number 21, which is stated that the parties were informed of the location of the GDC hearing. Therefore, the argument by the appellant that there's no notice does not stand.
No. It was only the
Thank you. And therefore, having dealt with issue B, I will now move to issue C, which we submit that the GDC did not err in deciding Ms. Tang is ineligible as she held dual citizenship. The appellant argued that Ms. Tang is ineligible and made two arguments. My apologies, Ms. Tang is eligible and made two arguments, which is first, the GDC had contradicted the reading of Rule 3 Clause 1 by ultra vires and the contra perfectum rule should apply. And second, Ms. Tang's sporting nationality is Guyana and she's therefore eligible. Members of the tribunal, we respectfully disagree. Our stance is that Ms. Tang is ineligible, and this is based on two reasons. First, Ms. Tang had failed Rule 3+1. Second, Ms. Tang had failed to disclose and declare her sporting nationality. And turning on to the first point regarding the interpretation of the eligibility rule, I would like to refer the tribunal to the qualifying game rules, page 2, Rule 3, specifically clause 1, which provides that a person is eligible to be a participating athlete if he or she is a citizen or permanent resident of a country in Asia. Now the entire dispute is, how can we interpret this rule? And before we go into the interpretation, allow me to lay down the rule of interpretation for issues concerning sporting nationality. Members of the tribunal, under sports law, there is an important distinction between sporting nationality and legal nationality. Legal nationality concerns how a state recognizes its individual as their citizen, but sporting nationality concerns the eligibility of an athlete. And to determine a person's sports nationality, they will look into individuals' legal nationality. But that is not the only criteria. There are other factors which the tribunal will consider, for example, the place of the residence and the parents or even your grandparents' born country. And just to show how wide this discretion can be, and Mr. Arbitrator, therefore the issue concerning sporting nationality is solely within the sports federation discretion and the determination of the sports federation. And to show how wide this discretion can be, I would like to refer the tribunal to two different rules. For example, in the World Rugby Rules, Article 8, to be eligible, not only you must be a citizen of that country, even your grandparents need to be born in that particular country. And in the International Ice Hockey Federation, you can only represent a country after playing for that country for 2 consecutive seasons. And members of the tribunal, the sports eligibility must be interpreted very strictly to satisfy the purpose of the games. And with that context in mind, let us look at the wording of the clause, which here mentions that an individual must be a citizen of a country in Asia. Now the appellant argued that Ms. Tang is a citizen of a country in Asia and she's therefore satisfied. But do not forget, she's also a citizen of a country in Oceania. And this is in excess of what is provided within the rules itself. And the rule is very clear as it does not allow any other citizenship which is not Asia at all. And therefore, both the primary and secondary citizenship must be confined strictly to Asia, and only then we can say she is a citizen of a country in Asia. And members of the tribunal, why this interpretation is so important? Because if we sympathize with one athlete today and to open the gate to let her in, it will extend to infinity entries. For example, dual nationality, triple, even quadruple nationalities. Then the question will be, when will this end? It will be a completely chaos, because at the moment we loosen the entry rules, the entire framework will be collapsed, and it defeats the very purpose of Rule 3, which requires exclusive Asian link. It will trigger objection and disqualifications, which will waste the entire Asian qualifying rounds. And ultimately, it will destroy the true legitimacy of the tournament. And if this door is opened once, it will never close again. Mr. Arbitrator and Madam Arbitrator, I notice that my time has ended. Can I ask an extension of 1 minute to wrap up my submission? Thank you. And turning on to the second point regarding the sports nationality by the appellant, basically they are arguing that her sports nationality is Ljubljana and by drawing parallel to the Olympic Charter. However, we submit that the Olympic Charter does not apply here as the primary authority is the qualifying game rules. And we do agree that sports nationality is distinct from legal nationality. However, for it to apply, there must be an unequivocal declaration by the athlete. However, there's never such declaration or even a disclosure by Ms. Tang ever. And the first time the respondent became aware of her dual nationality status is after the qualifying rounds, which was revealed by the news. And due to her failure to declare her sports nationality, left her status uncertain, and she still has the ability to switch nations in the future. And therefore, due to such uncertainty, her exclusion was the only correct and lawful outcome under Rule 3+1. And with that, it brings us to the end of the submissions. If there are no further inquiries by the tribunal, thank you. Then I shall conclude my submissions. Thank you.
Before I begin, could I confirm that the members of the panel can hear me and see me clearly? Thank you. Members of the panel, 1 point in rebuttal on the first issue regarding biasness. Fish in the sea. This is what the respondent has been using, but we have to take a look at what sea did the GDC actually select its pool of arbitrators from. If I could turn the members of the panel from para 26 to 28, which shows the direct composition of the tribunal. Miss Elise, a member on the tribunal, is simply just an individual who is experienced in doping cases, and she's just a panelist on talks on doping of esports. And Mr. Douglas, on the other hand, is simply an online streamer and gamer, and nowhere does it state that he's an expert in Quidop. This shows that the GDC has selected from a pool that's not simply restricted to only individuals experienced in Quidop, rather individuals who just know about esports and doping. Therefore, if we simply restrict the idea of arbitrators in our case to only one's experience in Quidop, yes, I will agree with the appellant on this issue. But clearly the GDC has not done that. Notably, Quidop is a new game, and naturally the individuals that are more experienced in it are just general esports enthusiasts and individuals who know esports in general. And therefore his submission regarding fish in the sea is way too narrow and should not be followed. Unless I may be of further assistance to the panel. This concludes my submissions. Thank you.
Good morning again, members of the tribunal. Fu Kai Chong for the respondent for the Seah rebuttals. The appellant raised that the three commissioners are not experienced enough and they are not fishers in the sea. However, respectfully, we disagree with 3 points. Firstly, Mr. Lander did not object to their expertise during the GDC quorum. Secondly, Ms. Farina is an expert shown in the mood problem. She's Miss Douglas is a streamer, yes, and Miss Alice has experience in doping cases. However, we have to understand the context of the case today. Quidop is a new sport. This is the first tournament held in Asia. There are not many experts around. Members of the tribunal, if I request my learned friends to judge the GDC quorum that day, they could not have done so because they do not understand the rules of the Quidop game. Therefore, we submit that these 3 members are the most suitable members to judge the game, and we cannot find any alternative commissioners. We hereby conclude our Seah rebuttals. Thank you.
Okay, the arbitration session has now officially adjourned. Arbitrators, shall we proceed to the feedback session, or shall we do it after the deliberation?
Sorry, is the deliberation gonna take place like together with the council present or in a separate room?
No, ma'am. We will ask the councils to kindly leave whilst the deliberation takes place. Once that's over, then we will invite them back for the photography session, for the feedback and the photography session.
Okay, I suppose I would suggest that we deliberate first before we move on to the comments. Is that okay with Asil and Erdina?
Yes, I think that would be good. Thank you.
Okay then, councils, you may now leave this hearing room whilst the arbitrators will proceed with the deliberation in the hearing room. You guys will then be re-invited by the organizing committee into the hearing room once the deliberation is over.
Leave, but then leave the
Thank
breakout
you,
room.
and see you later.
Thank you. Say thank you.
Thank you.
Okay, fuck it. Just leave.
Yeah, dude, can you give me the clarification pages? Do you have the clarification?